Hello and welcome to the first video in our video series on recent data protection decisions from the Court of Justice of the European Union. Today I'm joined by my colleague David O'Connor from the Technology and Innovation Department here at Arthur Cox, and we're going to be discussing 4 recent judgments that relate to the right of access to personal data under the GDPR.
Thanks, Aoife. Great to be here.
So let's start with case C154/21, which is one of the Austrian post cases. Here, the data subject had made an access request under Article 15 GDPR, and in addition to seeking a copy of their personal data, they also wanted to know the identities of any recipients of their personal data. Can you summarise for us the key legal question that was referred to the court and also the outcome of the case?
Certainly. So the court was asked to consider whether Article 15.1 GDPR entitles data subjects to receive information regarding the specific identity of recipients or whether categories of recipients is sufficient. The court held that a data subject must be provided with the actual identity of the recipients of their personal data unless they elect in their access request to receive categories of recipients only. A controller is not required to provide the specific identities to recipients where it can demonstrate that it is impossible to do so, for example, where the identity of the recipients are not yet known, or where the controller can demonstrate that the request itself is manifestly unfounded or excessive.
Thanks, David. Controllers having to disclose the specific identities of recipients to data subjects in response to an access request is likely to be a big lift for a lot of them. The next case we're going to talk about also relates to recipients, and that's case C579/21 or JM. What happened here?
So the data subject in this case was both an employee and a customer of the controller, which was a bank. After learning that his customer data had been processed by other members of the bank staff, the data subject submitted an access request to his employer requesting the specific identities of the other members of staff who had processed their data and the reasons for such processing. The bank refused to provide this information, stating that it was the personal data of the employees concerned, and the court was asked to consider whether Article 15.1 GDPR should be interpreted to mean that the identity of persons who process personal data constituted information which an individual was entitled to receive pursuant to their access request.
Interesting. And what did the court decide here?
So the court held that employees of a controller are not considered recipients within the meaning of Article 15.1c, where they process that data under their employer's authority and pursuant to its instructions. The court also held that the GDPR does not lay down a right to know the identity of employees who carried out processing operations, again, under their employer's authority and pursuant to its instructions, unless that information is essential in order to enable the data subject to effectively exercise the rights conferred on them under the GDPR. And even in such cases, the controller must, of course, consider the rights and freedoms of those other data subjects before handing over any personal data.
Thanks, David. Okay, let's move on and discuss what the court had to say about the concept of a copy of personal data in relation to Article 15 GDPR. So case C487/21 is another case that was referred to the court by the Austrian courts, and that case focused on the question of what form a copy of personal data should take. Could you tell us about the judgment?
Yes, of course. So the court had to determine what the meaning of copy was within the GDPR, despite the fact the term itself is not actually defined. The court held that the main requirement was that data subjects have the right to receive a faithful and intelligible reproduction of their personal data that's undergoing processing. So the focus is on the personal data undergoing processing itself, rather than the form in which the data is provided to the individual. However, the court did say that in some circumstances, the data subjects would be entitled to extracts of documents or copies of documents themselves, or indeed extracts from databases where this was necessary to vindicate their data access request.
Thanks, David. So in our final case then, which is case C307/22 or FT and DW, the court addressed the issues of fees for access to personal data. Can you tell us what happened in the case?
Yes, so in this case, the data subject was requesting free of charge a first copy of their dental records following what they believed was negligent dental treatment. The dental practitioner refused, stating that the reasons for the request were not provided for in the GDPR, and they also requested that the plaintiff cover the costs of providing the copy of the data as provided for under German national law.
Okay, so in other words then, the court needed to decide two things. One, whether national legislation could be relied upon in order to charge the data subject a fee to receive a first copy of their personal data. And then two, whether an access request with the aim of seeking to verify or support a possible legal claim should be restricted. What position did the court take?
Perhaps unsurprisingly, the court held that charging fees for data subject access requests is incompatible with the GDPR. This is particularly the case in relation to first copies of personal data, where controllers are required to provide access to data subjects free of charge, irrespective of the reason for the access request. The court held that this was the case even where the reason for the access request is not related to the reasons set out in Recital 63 GDPR, namely for data subjects to be aware of the processing their personal data is undergoing and to be able to verify the lawfulness of such processing.
Okay, and did the court say anything about subsequent copies of personal data?
Yeah, this is something the court did comment on. The court noted that the GDPR allows controllers to charge a reasonable fee for subsequent copies of personal data, and of course controllers can also protect themselves from abuse by providing reasonable fees for requests that are manifestly unfounded or excessive.
Okay, thanks David. So the European Data Protection Board has announced that its next coordinated enforcement action will focus on the right of access. Can you tell us a little bit about that?
Yes, so 31 supervisory authorities across the European Economic Area are participating in this action, including the Data Protection Commission. The DPC has indicated that it will send questionnaires to 30 controllers across the public and private sectors to aid this fact-finding exercise. And the results will be aggregated and analysed in a coordinated manner, leading to a European-wide report.
Okay, so definitely more to come on the right of access then.
More to come.
Okay, thanks very much for your time today, David, and thank you all very much for watching.